Well, here it is, the bottom of the hour. Let's go. And then we're back. Good morning, everyone, and welcome. Before we an investigation into the grand jury, now and then. This morning, we are going to walk through an investigation of the history of the grand jury, where it came from, and what it became, and why that matters. Most people hear the words grand jury and assume the system we have now is the same thing the founders preserved. It is not. What exists today is not the same in spirit, in function, or in independence as the grand jury that developed over the centuries and was preserved in the Constitution. So here we go. Let's walk through this clearly, step by step, investigation in order. To understand the grand jury correctly, we have to go back further than most people are ever taught, as early as 997 AD, under King Ethelred of England. Groups of sworn men were required to report crimes in their communities. They were charged to accuse no innocent person and conceal no guilty one. This was not yet the fully developed constitutional grand jury, but it shows something critical. The idea already existed. Local men from the community sworn to speak truth, and that matters, because the idea existed before the system was formalized. Then, in 1166, under King Henry II, the Assize of Clarendon is established. Now we have a system, a jury of presentment. Men sworn to report suspected crimes to the crown. This is the first recognizable mechanism. But be precise here. This system served the crown. It was a mechanism of accusation, not yet a protection of the people. Then, in 1215, the Magna Carta. Now something changes. Power is restrained. Lawful judgment matters. Magna Carta is not just symbolic. It is a direction, limitation on authority. Clause 39 establishes that no free man can be imprisoned or punished except by lawful judgment of his equals or by the law of the land. This is the shift from ruler-controlled accusation to community-based judgment. This is where the foundation of the grand jury begins to transform from an arm of the crown into a restraint upon it. It introduces the principle that accusation must be grounded in the people, not imposed from above. That principle is what later becomes presentment and indictment. Without Magna Carta, there is no legal foundation for an independent grand jury. The system begins to shift from serving authority to restraining authority. Through the 16 and 1700s, grand juries operate with real independence. They could investigate on their own, refuse pressure, decline indictments. They were not controlled. They were a shield of the people. Now we arrive at 1791. The grand jury is preserved in the Constitution through the Fifth Amendment. And this must be clear. A person cannot be held to answer for serious crimes without a presentment or indictment of a grand jury. That is not minor. That is constitutional protection. So the timeline is clear. 997, the idea. 1166, the mechanism. 1215, the rights foundation. And 1791, preserved in the Constitution. Now, if that was the foundation, what changed? Before we move on to the Reconstruction era, I want to insert 1849. This was the year that California wrote its first constitution. It was a traditional system, and grand jury was required. Now we move to the Reconstruction era of 1865 to 1877. Particularly after the Civil War, federal authority expands. trust in local population declines, and central control increases. These are the conditions for change. Then, in 1879, California changes their constitution, and something very critical happens. Prosecution by information is introduced. What this means is a prosecutor can bring charges without a grand jury. The grand jury is not removed, but it is bypassed. And the reasons given? Efficiency, speed, practicality. This is not a small procedural change. This is a structural bypass of the people. Because before this, the grand jury stood between the citizen and the prosecution. After this, the prosecutor can go directly to charging. That removes the requirement for citizen review before accusation. The grand jury becomes optional in practice. And once something becomes optional, it begins to disappear in function. This is the first major break in the people's control of accusation at the state level, and California becomes a model that other states follow. So this is not isolated. This is a template. Then, in 1884, Hurtado versus California. The Supreme Court rules that states are not required to use grand juries. This opens the door nationwide. Now states can move forward without them. In the early 1900s, control shifts even farther. The reasoning? The law is too complex. People are not trained. Experts are needed. And step by step, the people move out of the center. Now, we come to the mechanism of change. This is not theory. This is how it was done. In 1934, Congress passes the Rules Enabling Act. They do not rewrite the grand jury. They do something more important. They transfer authority. They give the Supreme Court the power to write procedural rules for federal courts, including the grand jury. Between 1941 and 1944, committees of judges and lawyers draft the rules, not the people. Legal professionals. And in 1944, the Supreme Court adopts them. Inside those rules, Rule 6, grand jury. In 1946, they take effect. Now listen carefully. This is critical. The Supreme Court created the rules, but they did not become binding on their own. They were sent to Congress. Congress had the power to stop them. Congress did not. They allowed them to take effect. So what happened? Congress did not directly change the grand jury. They changed who controls the rules. And once you control the rules, you control the system. And this is what happens during the World War II era, a time of federal expansion, central coordination, administrative control. Before this shift, the grand jury is independent, it acts on its own knowledge, it stands between the people and power. After this shift, it operates inside a system. The prosecutor drives it, and the rules define it. World War II ends, and millions of Americans come home, but they don't come home the same. They've seen things, endured things, what we would now call trauma, then called shell shock. A nation that just fought for freedom now has to figure out how to live with what it's been through. The late 1940s and 50s became a time of rebuilding families, communities, institutions, but underneath the surface, something is shifting. Authority is being reorganized, systems are being formalized, and fewer people are asking questions about how power actually works. Then we move into the 1960s, a decade of upheaval, civil rights movement, protests, political assassinations, distrust in government. The American people are no longer unified, they're divided, distracted, and reacting. And in times like that, most people aren't watching what's happening inside the system. In 1974, we reached the lock-in. In United States versus Calandra, the Supreme Court rules that the exclusionary rule does not apply to grand jury proceedings, meaning even if evidence was obtained illegally, it can still be used in front of a grand jury. Now understand the impact. The grand jury is no longer acting as a protector against government abuse. It is now allowed to hear evidence that would be thrown out in a trial court. So the shield is weakened. The standard shifts from protecting rights to securing indictments. And because the grand jury only hears what the prosecutor presents, this strengthens prosecutorial control even further. The country is under pressure again. Watergate scandal has shattered trust in the government. Gas lines stretched for blocks during the 1973 oil crisis, and after years of conflict, the United States is still feeling the weight of the Vietnam War. Then something unthinkable. Richard Nixon resigns. The system is shaken, the people are distracted, confidence is low. And in times like that, most aren't watching the fine print. Decisions are made, lines are redrawn, and very few understand the long-term consequences. What looks like a response to chaos becomes a shift in how power operates. And that brings us to 1992. In the United States versus Williams, 1992, the Supreme Court rules that prosecutors are not required to present exculpatory evidence to the grand jury. This is critical. Exculpatory evidence is evidence that could prove innocence does not have to be shown, so the grand jury is no longer a fully informed body. It hears one side. The prosecutor controls the narrative, and the grand jury cannot make a truly independent determination without seeing both sides. This locks in the transformation. The grand jury is no longer an independent investigator. It becomes a body that reviews what is given, not what it seeks. Prosecutors are not required to present exculpatory evidence. Now, control is firmly established. Let's step back and look at it. 997, 1166, 1215, 1791, 1849, 1865, 1879, 1884, the early 1900s, then 1934, 1944, 1946, 1974, 1992, step by step by step. So what is the simplest way to say it? Then the people investigated and the government answered. Now government investigates and the people observe. To conclude, the grand jury was not removed, it was redirected step by step. And if we do not understand what it was, we will not recognize what it became. What we have just shared is not a theory, it is a trail, a documented, step-by-step transformation from a system where the people held power to a system where the power was managed, redirected, and contained. The grand jury was never meant to be passive. It was never meant to sit quietly and simply agree. It was meant to stand, to question, to investigate, to act independent of influence, independent of pressure, independent of government itself. That was the design. And if that design has been altered, then the question is no longer historical. It becomes personal. Because a right that is not understood is a right that will not be exercised, and a power that is not exercised does not remain with the people. So the question is not just what happened. The real question is, what will we do now that we know? I'm going to thank you all for coming. I know many of you are going to go along with your day. Be blessed, and just go out there and shine the light.